Hello everyone and welcome to our May webinar. Fantastic to see some returners from last month's webinar and brilliant to see some new names as well that are joining us for the first time. So please do spread the word. Thank you to all of you who are joining me live and also for those of you who are watching the recorded version either on our YouTube channel or via our website. You are all very welcome. Also welcome to Doyle Clayton. Doyle Clayton is a specialist workplace and commercial law firm. We have offices in London in the city, in Reading, and our newly opened office in Bristol. And we help businesses across the UK, Europe, and globally with their workplace issues, their employment issues, immigration issues, as well as their commercial and corporate issues as well. We also have specialist pension teams, immigration teams, as well as data protection. And we also support with employee ownership trusts as well. So please do get in touch with me if you want to hear more about what we do and who we help. Also, for those of you who don't know me, Emma O'Connor, I'm a partner here in the employment team at Doyle Clayton, and I also head up our client training team. So again, please do get in touch. And who doesn't love a QR code these days? If you would like to be LinkedIn friends, then please, if you hold your camera up to this slide, you will be able to link in with me. So looking forward to linking in with you later. But here's my email and my phone number as well. Also fantastic to have launched and grown our training initiative, training for HR teams, for managers and wider employee populations, not just in employment law, but also across the full spectrum, obviously, of workplace topics, as well as regulatory issues and leadership as well. We tailor our training to suit our audience, as well as methods of delivery and also your budgets. So again, if you want to hear more about HR training, leadership and management training, then again, please do get in touch. We are relevant, relatable and always responsive. Just to give you an idea about what training I've been doing since I joined Doyle Clayton back at the beginning of April, lots of training on preventing sexual harassment in the workplace, particularly for managers and for boards as well, board leadership training, because it's important as well that our senior leaders within businesses understand the importance of preventing sexual harassment at work. So yes, lots of sexual harassment training. Also immigration training, right to work checks, and also looking at the employment law aspects of immigration law and how those two legal topics interact, sometimes harmoniously and sometimes not. Also doing training for management teams on how to basically conduct fair and reasonable disciplinary processes. So what does that look like, particularly around investigations, decision making, what sanctions are available for managers, and also sort of core skills, listening skills, asking questions during the disciplinary process. So again, lots of different training topics and opportunities there. So again, get in touch. I am really excited to be launching the 2025 HR Masterclass. Really excited about this one. This is going to be in-person, day-long course in our Reading, London, and also in our Bristol office as well. But the London and Reading Masterclasses will be coming up in July. As I said, it's an opportunity to spend a day. I will be leading the sessions, and really they're aimed at people who are new or mid-level. Perhaps you are new to an in-house role and haven't had any employment law experience. So it really takes you through the full kind of employee lifestyle cycle, you know, what is an employee, who is an employee, contracts, policies. We'll talk about the role of HR and why HR is so important and how you can kind of increase your HR voice within an organisation. We'll then look at how can we support the business with its initiatives with regards to equality and diversity. So looking at the Equality Act, protected behaviours, protected characteristics. And yes, I will be talking about preventing sexual harassment in the workplace. And then we'll use all that fantastic knowledge to then talk about how we can support the business through ER processes, so practical, relevant tips and techniques for conducting disciplinaries, grievances, managing absence. We'll also be having a look at family-friendly rights. Bit of crystal ball gazing, what's coming up, and again, where can HR have impact? Small groups. This is a paid for course because we do run it in small groups, classroom style, to really allow for interactive discussions. So invites are coming out for that imminently. So I really do hope that you're able to book or recommend people in your team come along and join me. It's a really great day, a fantastic learning opportunity as well for those in our HR teams. I've had HRDs as well. So again, you know, who want to come and learn more, best practice, HR best practice, learn from me. So you get HR best practice as well as the employment law angle as well. Another date there for your diary is our next webinar. That's going to be on the 11th of June, again, 12 till 12:45. That's going to be about navigating the employment tribunal. So even if you have not had the pleasure of having an employment tribunal claim, I think it's really important just to get prepared to understand more about the process. How can we get the most out of early conciliation? How can we, you know, put together witness statements, document disclosure? Again, it's about really looking at how we can navigate and effectively navigate the employment tribunal process. Also, I want to tell you about a new podcast that we've launched, DC Talks. The first of those in the series was talking about the 4 Women Scotland judgment and some tips there for HR teams and businesses. So again, if you've not checked out our podcast, we are available on all podcast sites, so Spotify, etc. So again, to check that out, and they're going to be a deeper dive into HR topics or a legal case, not necessarily HR or employment law related, so a broader topic there. So today is a case law update. I'm going to be looking at some of those recent cases which maybe have hit the employment headlines, and some of them maybe you haven't come across. Just to give you a little bit of housekeeping, obviously I am live, and today really is about giving you the facts, looking at the decision and giving you some tips and some ideas as to maybe some takeaways. It is a mix of cases, so looking at absence management, looking at reasonable adjustments, disability discrimination, also looking at language and behaviour, and again how that can turn into harassment cases within the workplace. It is an overview, it's just a general discussion. Please, if you've got any questions, you know, put them in the Q&A, and I will do my best to kind of deal with them as we go through, or I will come back to you after the event. But this really is no substitute for taking your own legal advice, or again, if you want to get in touch with me after about how I can help with anything specific. So just a little bit of housekeeping there. So, without further ado, let's have a little look at the first case that I want to talk about. So the first couple of cases are looking at absence management, because I do think that is one of the kind of it's too difficult pile of cases that we see managers not really engaging with, and then obviously that having a knock-on effect in terms of how effective HR and the people teams can be in kind of supporting the employee, but also kind of, you know, supporting the business as well. So in this case here, the individual had a lot of sickness absence between 2019 and 2023. In particular, one period of sickness absence had been for over 130 days. The individual in question did speak to their manager about it, and they did talk and have meetings about their absence, and they did ask for hours to be reduced to support the individual who had numerous mental health concerns and complaints. The employer did send the individual to go and see occupational health, as is normally standard in these types of cases. But occupational health actually came back and said, no, the individual was not disabled for the purposes of the Equality Act. Again, thinking about that physical and mental impairment, substantial, means that symptoms will last, or periods of symptoms will last for 12 months or more, and the condition has an adverse effect on a person's ability to carry out normal day-to-day activities. But the employer didn't interrogate that report that they received. Things carried on, absence was not addressed, and in 2023 the individual was dismissed for their poor absence record. The individual brought a claim in the Employment Tribunal for unfair dismissal as well as disability discrimination. So what was the outcome of that case? Well, the courts basically just said that the fact that the employer in this case had reached the conclusion, given all the evidence, all the absence, all the, the reasons for the absence, the fact that the employer came to the conclusion that the individual was not disabled for the purposes of the Equality Act was irrational and wrong. The employee should have been given greater opportunity to discuss with the employer about why she was off, how the employer could support her and encourage her to return to work and support her when she was at work as well. And the court did find that the employer in this case had really failed in this duty to take those and to make those reasonable adjustments to her role to allow her to return to work and to stay in work as well. And they found that she had been treated less favourably, that there was an element of disability discrimination there, less favourable treatment. And the claimant in this case was awarded £50,000. So again, you can see the consequences there, the financial consequences of a Disability Discrimination Act claim in this case. And as you can see, this was a case involving an NHS trust. Another case, again, similar, and it does involve, it's another NHS case, and this is about supporting individuals following illness. And in this case, a very, very serious illness that happened to the individual in 2016. Individual was working as a nurse, as a community nurse, suffered a brain hemorrhage and was off work for a substantial period of time. The impact of the brain hemorrhage impacted upon loss of memory, in particular, as one of the ongoing symptoms there. They do return to work in May 2018, but off again with symptoms related from the brain hemorrhage, and they're again off there, as you can see, from October 2019 until February 2020. Now, when the individual returned, initial changes were made to the individual's role. So rather than being out in the community, the individual was more hospital-based, more patient-based, and was seen by occupational health. So occupational health were involved, and they did make recommendations to support the individual through the use of auxiliary aids. One of those was a voice recorder. So again, that ability to be able to immediately record patient symptoms, recommendations, outcomes, and for that to be kind of automatically printed as well onto the patient's notes, rather than waiting and potentially there things being missed, symptoms, etc., being missed. So that was, laptop, software, recorders, and again, sort of general kind of, the ability to be able to instantly print. So unfortunately, the employer took 6 months to really do anything substantial. As I said, there were some initial changes that were made to the individual's role, but pretty much they were forgotten, and the employee was told to, give it a go back in their previous role. And after 9 months, again, they only really kind of got involved with the whole auxiliary aids and supporting the employee with reasonable adjustments. Employee felt overwhelmed, constantly having to chase the employer to do something, to kind of react and support them. And unfortunately, the employee's depression relapsed. They suffered a mental health crisis, and it ended up with the employee basically going to the employer and saying, I can't do this. And the employee was actually took early retirement. So tribunal claim again was brought, and perhaps no surprise given the employer, given the size, the resources, and also the huge delay here that the employer failed in its duties under the Equality Act. So again, not engaging with the recommendations of occupational health, not listening to the employee. Again, it wasn't right, that it was constantly, the onus was on the employee to keep chasing the employer. And again, when aids were provided, things did happen, despite the fact it taking months for this to actually happen. That obviously there is an issue there around there wasn't any training or support that was given to the individual. It was very much, I'll give it a go back in your old role. And also when the aids were provided, there was no training given to the individual. It was, here's your new laptop and your recorder, off you go. And this left him, and his evidence was, this left him incredibly vulnerable, but also the patients as well. Now, what I want to do in this case is I want to sort of break down exactly what the compensation was, because it's a really big award. I mean, over £200,000 is a really big award. And when I'm running training sessions on Equality Act, being an inclusive leader, I talk a lot about unlimited compensation. And yes, there are kind of caps and there are limits there, injury to feelings, we have the Vento bands. But when we talk about it being somewhat difficult to be able to predict compensation in a discrimination claim, it really is so, because the amount of different heads of claim, as we call it, are so vast when we think about compensation for discrimination. So again, £30,000 for pain and suffering, injury to feelings, how hurt, how damaged is the individual by the discrimination, by the harassment, that they have gone through. And again, the larger the award there in terms of, is it a lengthy, how long has the campaign of bullying or harassment gone on for? It can be for a one-off act as well. So again, injury to feelings. We've got money, haven't we, there for financial loss, past loss, future care lost. We've also got sort of financial claims as well, interest, and a whopping £55,000 for what's known as grossing up. So basically the employer taking on the employee's tax burden there, grossing up. So again, an NHS case, and the NHS being judged as, a massive employer, lots of resource, lots of HR professionals to be able to support. So again, a massive claim there, and massive compensation. So these claims are important, individually, for a business, but also financially as well. So what are my takeaways when we think about managing absence, when we think about disability discrimination? Well, it was clear here there, in both these cases, there was very little communication. Very little communication between managers, people teams, occupational health, other medical professionals, and also the individual. When we think about managing employees, managing people back to work, it really is about having that blank canvas, having that roadmap. How are we going to get from point A to point B? And that involves communication, listening to the individual. What do they want? What are their expectations? What do they need as well? Allowing somebody almost to take 130 days of sickness absence without there really being any plan or support, I'm afraid, is not good enough. Also, internal processes, managers raising concerns. What does that look like? Return to work interviews, logging absence, raising concerns. The managers are so important when it comes to absence management. They really are at the front line of this. So again, what do they know? Do they know that they need to raise concerns, or is it like someone's off, let's just forget about it and we'll just carry on as normal? You know, without training and support to really help people teams and help individuals as well, you know, the whole process does not work. Early intervention, again, 130 days of absence, you know, really should not have got to that stage. There should have been, you know, support given early on about how the employee, how we can support them, get them back into work and keep them back in work. As we know, disability discrimination is different. There is this positive, proactive duty on employers to make those reasonable adjustments to encourage and support people back into the workplace and to keep them back into the workplace. Again, what steps can the employer reasonably take in that? Yeah, if you're a bigger employer, you're going to be judged. As we saw in the two cases here, you know, you're going to be judged more harshly than perhaps smaller employers. But similarly, you know, if there are reasonable adjustments that could have been made and they weren't, you know, there is really little an employer can do to defend that. And I do want to mention medical reports as well. Medical evidence is incredibly important in these types of cases. Employers are expected to take external medical advice. You know, we're not doctors, but also once you get that advice, not to follow it without, you know, questioning it or really kind of judging it on what you are seeing. If occupational health are saying this person is fine, but then they're taking huge swathes of sickness absence, maybe there's a disconnect between what the occupational health provider is telling you and what you're seeing on the ground. So yes, medical evidence is incredibly important. You are expected to take, you know, to take medical advice, but again, it's not taking it completely, you know, verbatim. It's about using your own discernment and your own judgment and using it to support your decisions. Yeah, yes, but not being the absolute dictator of them. And again, as you've seen there with the compensation, you know, there are risks and consequences that need to be considered when we think about managing absence and managing people back into the workplace, particularly when they've had a serious injury or illness. So moving on then from disability discrimination, but again, looking at another area of potential risk here around kind of ethnic, national origin, around kind of race and race equality. And this is a case which involved an individual who was in their probation period. Their probation had actually been extended twice, and their role was marketing, engagement and partnerships manager. So a lot of communication in that role, a lot of verbal communication as well as kind of written communication, events, etc., etc. As I said, probation had been extended twice. The individual's manager had raised concerns about the individual's strong accent, that perhaps it was difficult for others within the organisation or externally to understand her. The individual resigned, having not passed probation, and brought a claim, because as we know, claims for discrimination and harassment, claims under the Equality Act, individuals, you know, they can be brought from day one. Individuals don't need length of service in which to bring claims. They can be brought even before employment has started. Again, it's a wider net. The Equality Act has a wider net. Employee resigned and brought a claim against the employer for harassment on the grounds of race. So were the manager's comments harassment? Well, possibly. So again, this case will now go back to the Employment Tribunal to actually look at the facts and decide on the definition of harassment. So again, you know, harassment, racial harassment. So again, does it have that purpose or effect of creating that hostile, intimidatory environment? Does it impact upon a person's dignity? Was it reasonable for the individual to have, you know, reacted as they did? Was it reasonable for them to have that view that those comments did create that environment, that working environment, which was hostile? So again, possibly the treatment could possibly amount to harassment. But again, it's now going to go back to decide if the facts of this case were indeed the reason why the individual resigned, and also could they be seen to be harassment. So again, lots of interesting issues there. And I think really in terms of kind of the takeaways, I think particularly in this case, is going to be the evidence, isn't it? You know, yes, saying that I didn't mean to offend, or, you know, it was just a joke, isn't a defence. But actually, what other evidence is there to support? You know, are there measurable targets? Are there objective reasons as to why communication was an issue, or could have potentially been an issue? So again, evidence is really important. Again, looking at the idea of this being unwanted conduct. So again, going back to that definition of harassment, and that's one thing that the court will need to look at. Does this fall within that definition of harassment? And again, thinking about that statutory defence there, what evidence does the employer have to support and to maybe use that statutory defence, taking those all reasonable steps? So again, I think that's going to be one case to watch, actually, and I'm quite interested to see if that case perhaps settles, or actually, you know, will the respondent and the claimant in that case go back to the tribunal and really hear what has to be said? Because I think it's actually a really interesting case there. This is one that you may have come across. It was quite widely reported, but I think it does throw up a number of issues, not just the issue of discrimination, and in this case, pregnancy related discrimination, but also about communication more generally, about how managers, how your staff are using, you know, the wonders of modern technology and phones, and perhaps, you know, maybe getting themselves into difficulties because of the way they are communicating with their teams. Now, that's not to say that, you know, text message, it's immediate, it's convenient, but yeah, it's immediate, and it's perhaps not as professional as perhaps we want to encourage in our leadership population. So the facts here are around pregnancy and around pregnancy related illness. So the individual there started work in March 22. In October she became pregnant and was suffering from morning sickness, and she told her manager, her male manager, that she was pregnant and that she was suffering from morning sickness. So again, open about kind of what was happening. During October and November, there was lots of texts exchanged between the employee and the manager around, you know, when she was working, was she well enough to work? Was she having some time off with the morning sickness, what the midwife had advised her to do or not do? And there was some accommodation there with the employer, with the manager, about how she could work, and certainly there was some allowance there for her to work from home. So there was some accommodation that was made. But then things became a little bit more unsure. The manager then is about to go on holiday, so he texts the individual and says, you know, in a text, you know, could you come in and support? You know, I appreciate you're unwell, but you can flex your time, but I need you to come in and help me if you are able to, but I need you to come in and help before I go off on holiday. Now, the individual said, no, I'm sorry, I can't come in, I'm too unwell. And then the manager sends text to the individual saying, look, you probably guessed by now that I'm going to have to find somebody who can be in the office. And he ends his text message with the wondrous jazz hands emoji. The individual there brought a claim. Now, the eagle-eyed amongst you will say, well, how can they bring a claim for unfair dismissal? Because they'd only started working in the March and were dismissed in the December. Pregnancy-related dismissals fall within that automatic unfair category. So if an individual is dismissed because they are pregnant or for a reason related to their pregnancy, it is automatically unfair dismissal. So the individual does not need the 2 years requisite service there. So again, something there to flag, you know, with your managers that not everybody needs 2 years service with which to bring a claim, and that's really important, and certainly going to be even more important as we move forward, don't we, with the Employment Rights Bill, which will be winging its way soon to us. But basically the court said, look, however the manager tried to dress this up, it was a dismissal. Yeah, whether you tried to sort of say, oh, I didn't mean it, it was just a text. No, the fact was, it was pretty clear, the fact that what you were intending. So again, we need to sort our communication out here. And also, it was accepted that she was treated less favourably. It was pregnancy related, namely the morning sickness, and she was awarded £93,000. Again, that is a big sum of compensation there. So again, compensation for discrimination really does have some teeth there. So again, something to think about. Methods of communication. Look, as I said, all businesses are different. But I think as people teams, we need to get a handle on how managers are communicating. I've said it before in my training sessions, and I'll say it here: do not swap, convenience. Do not swap professionalism for convenience. Basically, if things should be in a proper letter, then or an email. If it's a work-related conversation, it should be, in my view, in an email or a letter. And particularly if you're taking decisions like this, it needs to be in proper channels of communication, and obviously giving employees the right of appeal, etc. So methods of communication, clarity of communication as well. Jazz hands emojis, no, and we shouldn't really be doing this. Again, letters, emails, formally doing, if you're going to dismiss them, it needs to be done in a formal way. And again, be aware of the risks of pregnancy-related dismissals, pregnancy-related illnesses. Again, something to have a think about there. And health and safety. One of the other things that was raised in this case was also that the individual said that the midwife had advised that there needed to be a risk assessment done, and the employer didn't do that. So again, health and safety also is something we need to think about when we are considering individuals who are pregnant or suffering from pregnancy-related illness. So some takeaways there. Another case, and I think this is important not only because of the kind of circumstances of it, but also what the claimant did and who she brought a claim against. Because again, I think this is an area where we forget just how wide and how encompassing the Equality Act is. And this, again, it sounds quite chaotic. It's, an individual started, there were lots of issues around her job, her role, her pay, shifts. So there were sort of other sort of wage type issues sort of bubbling on it in the background. But also there was conversations that took place between the individual and the owner of this particular antiques dealership, very perhaps gendered language, asking the female member of staff, about her need to work, does she have a husband, that she was lucky to have this job. And the other point about this case is that there was evidence, the manager sort of, I don't remember saying all of these comments, but hey presto, the individual kept a contemporaneous diary of what had happened. These were typed notes, dated, so again, could show that they were written at the time. So she did have evidence of the fact that, conversations happened, what was said, etc. So a kind of an evidential point there as well. This is a tribunal claim actually heard in the Reading Employment Tribunal, when here the tribunal judge did accept that the language, husband, basically suggesting that, outdated language around, men being the breadwinner and should women be working, why are you working, was inherently sexist. And the claimant in that claim was awarded, as you can see there, £56,000. Again, there's some wage issue type claims in that as well. But again, the comments were harassment on the grounds of sex. Takeaways. And again, I want to just flag here, and you can see, this was a claim that was brought against not just the antique dealership, so the employer, but also the individual and named individual. And again, under discrimination law, under the Equality Act, claims can be brought against employer and named individuals. And that's always one when I'm doing my training to really get the attention of the management audience there. Also remembering, harassment encompasses not just sexual harassment, which is obviously what I've been talking a lot about, preventing sexual harassment, that unwanted conduct of a sexual nature. Again, we're looking here about harassment on the grounds of sex. And again, remembering that it's, we're focusing, aren't we, a lot on sexual harassment because of the new duties from October, and obviously some changes that we've got coming down the line, but also remembering harassment as well. Harassment based on or related to a protected characteristic, again, is something that businesses need to be focusing on. And the tribunal accepted that the respondent would not have asked a man or spoken to a man or made the same comments to a man. And again, no statutory defence. So, had the employer taken those all reasonable steps, businesses, employers are vicariously liable for the acts of their employees. Again, if the employer had been able to show, look, we've taken all reasonable steps to stop, managers going off and making these comments, it could have ended up very differently. It could have actually ended up with the individual being responsible, the named respondent there being responsible, and the employer being able to have that statutory defence. So always worth looking at your practices and your processes. There have been other cases, haven't there, that have been in the press. I'm not going to talk too much about the 4 Women's Scotland decision, because actually I've just done a podcast on it, so I would direct you to go and listen to that podcast, DC Talks, where I talked to Peter Daly, who is a partner in the employment team here at Doyle Clayton, who also represented complainants to the Supreme Court case. So again, I would invite you to go and have a listen to that podcast in 20 minutes, but that's just a really nice overview of the decision. Also, interim statement, haven't we got the interim statement from the EHRC? Remembering this is a statement of the law, it's not guidance. And also we've got some another statement that's been issued, haven't we, that came out, I believe, last night, so that would have been on the 20th, which is around looking at guidance for those who operate in the sort of the public sphere, so restaurants, leisure and hospitality, gyms, etc. So I would invite you to listen to the podcast. Also, review your policies and your practices. We've got a very clear statement there of the law. So again, go back and have a revisit, and please do take advice, because not every employer is going to be the same. Not every floor plan of your business, office, work site is going to be the same. So again, please do take advice. Also, lots of cases, aren't there, around social media use, private social media use, when that comes into the workplace, and obviously this kind of grey area around reputational damage for the employer. Higgs Farm School there is probably one that's sort of foremost in people's minds at the moment. But again, I think, I can't stress enough, take advice. I think avoid those knee-jerk reactions. It's all about balance and proportionality. Looking at your policies, looking at your processes. If you're going to say that our reputation has been damaged, well, okay, well, what evidence have you got of that? So policies, processes, also thinking about their, what does that mean in terms of training? And again, not all employers are going to be the same on that one. So that's something to have a think about there. And so again, I would urge you to sort of take advice on these cases, because again, it's one, all the context is different, and the facts of each case is going to be incredibly important. But the key takeaway, particularly on the social media case at the moment, is to avoid those knee-jerk reactions. We're going to dismiss immediately, or we're going to suspend immediately. Pause, reflect. and really investigate. And that's where investigations are incredibly important. Again, if you want support with investigations, then please do give me a shout, because we're working with businesses going in and doing high profile, investigations confidentially as well. Okay, so where are we in terms of the cases that we've talked about? I think really, again, just to sort of repeat, really, it's the importance of evidence, isn't it? And the investigation process is going to be crucial to that, making sure that your investigation is untainted, and making sure your investigations are unbiased, that they are really independent, that you are looking at all evidence, good and bad. It's not about we are only going to look for evidence that basically gives us the answer that we want it to give us. Early communication, again, those of you that have listened to me before, those of you that have been in one of my training courses will know it's a massive big soapbox issue of mine. It is far easier to deal with issues, be it conduct, absence, performance, early than if you've got somebody who's been off for 400 days. So again, early intervention, and that's where training managers, getting your policies out, communicating your policies, making sure that people understand, how do you report sickness absence? What are the triggers? When do the people team need to know? When are we going to get occupational health involved? What are we going to do with that report? Are we going to solely rely on it? No, because we should be making our own interpretation. So again, communication and early intervention. And again, thinking about the statutory defence, that ability of employers to say in discrimination harassment cases, yes, we know we've got separate, mandatory duties there for sexual harassment, but, what can we demonstrate that we've taken those reasonable steps, all reasonable steps? Have we got training? Have we got, do we monitor the effectiveness of what we are doing as an organisation? And really there are some opportunities there for HR and people teams to really kind of have an impact on the way that behaviours have perhaps been tolerated within an organisation, perhaps issues swept under the carpet. It's no longer good enough for businesses to just say, well, that's just a them thing or an HR thing, or we're just going to sweep it under the carpet or let somebody, kind of roll on to the next organisation. So there are some real areas there that HR can support. We have had some questions I can see. Let me just have a quick look and see what those questions are. Thank you so much for engaging and kind of asking questions. So just a question there on the podcast. So the podcast is called DC Talks, as in Door Clayton, DC Talks. So do check that out and like and subscribe. So thank you for that question, Yasmin. That's brilliant. And I'll send out the link afterwards as well, so people can have a listen to that. I had a question in from Anna. Thank you so much, Anna, for your question. That's much appreciated. So how long do court proceedings usually take, and are employees legal costs compensated? Well, June's webinar is actually going to be on the Employment Tribunal process, so we will be talking about that. But just to give you a little sneaky peek, no, in the Employment Tribunal, legal costs do not automatically follow. So it's not like a civil court where the loser pays the winner's costs. However, depending on the way the case has been litigated, claimants can make a claim for their legal costs to be funded, but also respondents can make an application for costs as well. So for example, say you made a really genuine offer, the claimant's actually been awarded less than what you offered, there was no need to drag this out, you've been put to extra costs, again, you can make an application as well. So don't want to give too much of a spoiler alert, but there are some things around cost, but it's not automatic. Gosh, court proceedings in the Employment Tribunal, again, it tends to be, days, but again, it can depend on the nature of the case. But what I would say is what we are finding is the time it is taking once a claim is lodged in the Employment Tribunal to getting to final hearing is taking, well, I'm going to say years actually, because it's taking, 18 months to 2 years, and certain tribunals, because all the tribunals are different, regional tribunals, you tend to get you will get allocated a different tribunal depending on where the claimant where the case sort of took place. And again, that varies. So it can take a long time actually for cases to be listed. And that's obviously has an impact on witnesses, costs, time, settlement. So again, some issues there. But next month's webinar, we'll be talking about that in much more detail. I'll be joined by my fellow partner, Mike Hibbard, who's a litigation specialist within the team. So again, really looking forward to that webinar. We've had another question through, thank you so much, around equality pay reporting. So not for this topic, but yes, if you check out last month's webinar, which was a legislation update, talking about that in there. But again, yes, being much more disability pay gap reporting, ethnicity pay gap reporting, we should already be doing, aren't we, if we are a larger employer, gender pay gap reporting. So again, something to watch. But yeah, do check out and also do subscribe, because all of this, the changes to the equality legislation, changes with the employment rights bill, we're going to be talking about it. Got a podcast series planned, also some briefings as well. So again, get onto that list, and again, keep up to date. That's how we kind of communicate with our audience. So join the webinars, join training courses, join LinkedIn, join our subscription to get our newsletters as well. So we're talking about this. I've had a couple of things. Let me just check the chat as well. Oh, brilliant. Yeah, no, fantastic. Thank you so much. So yeah, the link to the podcast and also the link to subscribe is in the chat. So please do that. And that's fantastic. And also thank you to all those people who have subscribed. We've got so many new subscribers. It's fantastic. So we're really kind of building that HR community, which is fantastic. So what have we got coming up? Again, as I said, we've got the next webinar coming up, so please do join us for that. Again, you'll get invites for that. So that's in June, and then July's webinar, we are talking about creating happy workplaces. So I'm really excited about that webinar as well. Contact details are there on the screen. And again, thank you so much for joining me today. And hopefully you've got some sort of tips and things you can take away. So thank you very much. And as I said, I look forward to seeing you all very, very soon. Thanks again. Bye-bye.